This morning we're going to talk about independent contractors versus employees and the benefits and weaknesses of that type of an arrangement for your business. Some of the benefits of choosing an independent contractor rather than an employee arrangement with your worker include not having to pay minimum wage, include not having to pay workers' compensation or overtime or unemployment. The other benefits include not having to pay payroll taxes. In fact, the employer merely gives the independent contractor a 1099 statement. The other benefits include limiting your liability. The employer is not vicariously liable for the negligent acts of the independent contractor. Lastly, the employer doesn't have to provide the independent contractor with any company benefits. Merely having an independent contractor arrangement does not mean that that will hold up upon judicial or administrative review. The intent of the employer and the independent contractor is not necessarily determinative. To qualify under the law, an independently established business must satisfy 3 of 5 criteria at a minimum. First, they must maintain a business location that is separate from the work of the employer. Second, they must bear the risk and loss of their work as shown by factors such as entering and negotiating their own contracts, warranting the services provided, or being required to fix defective work. The independently established business needs to provide the contracted service for at least 2 or more different entities or persons within a 12-month period. The independently established business must make a significant investment in the business. Lastly, the independently established business must have hiring and firing authority over the individuals performing the services. While state law is set forth in Oregon Revised Statute 670.600, each state entity is responsible for administrating the law in their own administrative proceedings. The Bureau of Labor and Industry, which governs discrimination actions as well as most labor complaints, applies a slightly different test, the right to control test. The factors under the right to control test include direct evidence of the right to control the end product or the work of the employee or worker, the method of payment, and whether or not the employee or worker has furnished their own equipment. Direct evidence of the right to control includes such factors as the hours of the employee or worker, whether or not there's a uniform, who's responsible for things like quality control, does the worker have other customers, who determines the rate of pay, was it negotiated, and who determines how and when the work gets performed. BOLI will consider the method of payment, including such factors as how the employee or worker is paid and whether or not the independent contractor pays the worker directly. BOLI will consider who furnishes the equipment. Does the worker furnish their own equipment? Does the worker purchase their own materials and supplies? And has the worker invested in the equipment, such as purchasing bonds or other insurance on the equipment? BOLI will consider the right to fire. How long has the job lasted, and is it subject to periodic renewal or automatic renewal? Lastly, does the contract provide any consequences for termination? The federal government, including the Internal Revenue Service and the EEOC, apply an expanded version of this test that includes at least 19 different factors, such as the right to hire and fire, the method of payment, whether or not the worker provides materials or supplies, and you can take a look at a more exhaustive list of those factors on your screen now. While there are benefits to an independent contractor relationship over an employee relationship, there are risks for getting it wrong. The employer could be subject to penalties or to civil liability for the acts of the employee. While there are benefits to the independent contractor arrangement, The employer who gets it wrong could be subject to claims for improper wage withholding, for wage claims, overtime claims, or workers' compensation claims. This can be a relatively complicated area, and the preceding slides are not meant to be an authoritative or exhaustive explanation. If you have questions about the classification of your worker as an independent contractor or an employee, please feel free to call us for a consult or schedule an appointment with Warren Allen.